You want to talk about fee pooling a little bit? Go ahead.
Wait.
Well, so like with our clerk, for instance, so and we talked about this morning with the other judges across the state. The amount of fees are very different from one county to another. We heard one county that said that they're receiving zero back from the clerk. We heard from one county that said that they're receiving $104,000 from the clerk. Ours has been very different as well. FY19 excess fees that were turned over were a little over $51,000. FY20 it was a little over $81,000, but for FY21 it was $39,000. So it actually dropped. So to answer the question, it is very different in each county based on what they're seeing. There's not a uniform answer to that.
An apples and oranges type thing.
It really is.
Okay. Thank you very much. I appreciate that.
Other questions?
May I respond also?
Go ahead.
I think that one example lends to the fact that a one-size-fits-all approach is not feasible for counties across Kentucky. We've seen that with some things in the past from other areas, and with that we know that it is so different from Scott County to Harlan County that's why it's important for us to work with the county clerks and keep doing it in the manner that we are.
Judge Mosley, with regard to your all situation, I know you mentioned, 50, 80, 39, I think, were the 3-year rolling average. Do you have an idea inside your county what the differences were in those years?
I know that in the first year of the collection of the document fee, that they generated an additional $26,000 is what the document, I think you all refer to it as the document storage fee to the clerk. That was what it generated in excess. Of course, costs, she hasn't adjusted wages other than the fiscal court has done pursuant to the administrative code a quarter on the hour for employees every fiscal year. That she has also adopted that. The rising cost of health insurance and pension obligations is another expense in that office, just like it is for all of us and you all as well. So that's pretty much what I can say about that.
Sure. Other questions? Anybody virtually have a question? Senator Howell has a couple questions.
Thank you, Mr. Chairman. Judge Mosley, I'll address this to you, but it could be to anybody. Have you had any discussions with your clerk about what it will cost to bring your clerk's office online?
Yes, and she's thought long and hard about it, and she thinks, right now, based on the amount of records in the office, I have no idea where she came up with this figure, but she felt like it would cost close to $750,000.
But you don't know the background on that or why?
I don't know where she got that figure. I don't know if she's had discussions with people that digitize records that have told her based on the amount of records in her office how much time it will take, but that was the estimate that she gave me.
Is your county along this process at all, or is she going to be starting from scratch?
She is going to be starting primarily from scratch.
What about cost for electronic filing? Have you had any discussions with her on that?
I have not.
Have you looked at anything on how that moving all of this stuff online can increase or decrease cost in the office and revenue in the office on a go-forward basis?
We have talked about that. She is very she works very closely with many of the title attorneys that come to the office frequently to research title opinions for homeowners that are trying to purchase homes. And all of those folks are very interested in seeing this available as a resource. But the thing that keeps being said by a lot of these folks to her are, well, the fee to record a deed just went from $17 to $50. What are we going to see next? Is there going to be another increase to make this available for everything to be available online. How's it going to be paid for? Are we going to have to pay for it, or is the state going to pay for it? There's a lot of questions concerning that. So she is very open, as I think most clerks are, to figuring out a way to do this. But at the end of the day, it comes down to where are we going to find the revenue to do it, and we don't think the $26,000 extra a year that is being collected is going to be able to pay to do all that.
How much of the clerk's fee money, if any, did the county sweep last year? Do you know?
Just what she returned in excess fees.
Okay. No, the 26,000 you talked about is just that recording fee.
The
that
doc,
$1
yeah, I'm
recording
sorry,
fee.
the doc fee. Yeah, so she turned over $39,000 in excess fees to the fiscal court.
Okay.
Yeah. So
I think that's all I have, Mr. Chairman. Thank you.
thank you.
JC, go ahead.
Thank you, Mr. Chairman. Mr. Chairman Howe, I've heard this statement before, and I'll just point of clarification, really. There's no sweeping of funds by counties with their clerk's office. That's not a term. It's turned over at the end of the year by the clerk. So it's not, sweeping is a state term used around the Capitol and with budget staff, and it's not really, so it's not a sweep. It's turned over at the end of the fiscal.
Okay.
Thank you.
Just vernacular.
Yes, sir.
Thank you.
Senator Wheeler, did you have another question? And this is more of a comment than a question, gentlemen, and I appreciate your all's openness and being here to answer the questions and things of that nature. I think as we have talked about this issue over the last year or so, and as we are developing committee as we move forward, I think we all understand the importance of the excess fee money in relation to the county budgets and how that all interplays with everything. I do think, and I'm speaking somewhat for myself, but I think somewhat for other members of the committee as well, that with regard to the permanent storage fee, I think that's where any real action may be on this issue as we move forward, at least in the near term. We had a bill filed on that last year. I think you all are fully aware of that bill. We talked about that some during session. But I think it was always the intent of the General Assembly that was a fee that was going to stay with the clerk's offices for this modernization effort and not be subject to the terms of the general excess fee rules, even though the other increases would be subject to the other excess fee rules. And I think one of the reasons we wanted you all here was to talk about that issue specifically and to understand and hopefully get some understanding from you all and from us that was a fee that hadn't been really counted on in your all's budgets, 2 years maybe now collections as of recently, but wouldn't be something that's normally being counted on. And I also do understand how hard it is to base anything off the last year or two's budgets because of the situation we found ourselves in. So I think we will maybe see some play in that issue with regard to the permanent storage fee and how that gets handled, but appreciate your all's input, and we want to continue to keep you all engaged in that process as we move forward too.
Chairman, may I have one more comment?
Go ahead.
And it's somewhat of a rhetorical question, is that we're the fiscal agents or the fiscal carriers of the county government. And so this permanent records fee or permanent document fee that we're talking about, when you look at the amount that Judge Mosley's talking about and the amount that his county would have to spend potentially to do that, that's nowhere near enough money to help his clerk's office to digitize. So in that scenario, the rhetorical question is, where's the money going to come from? And there's only one answer for that. That's from the fiscal court. Therefore, that would lead to the conversation, if we're going to have to spend the money on it, we would also like to have oversight on the fees that should be going to that modernization as well. But as you all move forward to discuss it in committee and discuss it in session coming up, we would truly appreciate the opportunity to sit down and discuss it more and expound on some of the points that we have.
Well, and I think we're trying to explore some other options too, with regard to making sure we get more of that library and archive money out into the clerk's offices for those grant processes, as well as we have asked for some guidance with regard to using funds because of the pandemic for those types of things at that level as well. So I think there's a lot of different things at play. There's not one single solution, but that's just all those things I think are a part of the process. So appreciate your all's time. Thank you very much.
Thank you.
Thank you all.
Now that we have kind of discussed that excess fee issue, we also wanted to, Hardin County Clerk Debbie Donnelly, I think, is on virtual with us. The main issue that Debbie is going to be talking about is how the counties that are over the population of 70,000 interact with regard to their excess fees. They have a different statutory. The other counties throughout the state, and Debbie, I think, is going to address that issue so that everybody's aware of how that works in counties. Debbie, if you'll just announce yourself for the record, and then you could proceed with your comments.
Yes, I'm Debbie Donnelly from Hardin County Clerk's Office. And today I'm going to speak on the over 70,000. We do it different than the under 70,000. We're on a 75-25, and what that means is that money goes to the state, to the Finance and Administration Cabinet. That 75% money goes for salaries, insurance, and pensions. And then the 25% goes to the fiscal courts quarterly. So what we do, that's governed by the fiscal courts. So for the 75-25, at the end of our term, then any excess money goes to our fiscal court. So none of that is kept in the county clerk's office at the end of our term. So at the beginning of our next term, we start out with $0. And so we have to make that money in January in order to pay our salaries. So, and as you all know, the majority of the money comes from our vehicle registration side. And our budget each year has to be approved through our fiscal court. So we present our budget for salaries, insurance. The 75% goes to that, and also your office expenses and your equipment. But we're, like I said, we're different than the smaller counties are, which they have to turn their money over at the end of each year. And if you have any questions, I'll be glad to answer.
Senator Wheeler.
Thank you, Mr. Chairman. So just so I'm understanding this process, because this is where one of my clerks made an inquiry of me about, I think even though we're under 70,000, I believe Pike County is treated as a county above 70,000. And she complained that I guess at the beginning of the year she had some extreme difficulties and some payroll issues and things like that. So on December 31st, you remit all remaining funds to the court. Is that what I understood, or?
If you're over 70,000 at the end of our term, then that money goes to fiscal court at the end of our term.
Oh, you're elected term.
Which is our elected term.
Okay, I
Yes,
got you.
for over 70,000. You're under 70,000, it's at the end of each year
Okay,
that goes, yes. But over 70,000, the end of our term, our elected term. So we start out at our next term in January with $0.
okay,
So we have to make that money in order to meet everything. But our budget does get approved through fiscal court, our county judge, and our magistrates.
okay. Thank you, Mr. Chairman.
Debbie, am I correct? Your 75% money is what you all send to Finance and Administration.
That's correct.
And you all remit that quarterly as well?
Correct. That
And then
money goes to, yes, that goes to the Finance and Administration Cabinet. And they also cut our checks or direct deposit for our salaries.
And then your 25% money, do you all remit that directly to fiscal court quarterly, or does it go through finance administration and then you get
It also goes through the finance, and then they cut that to the fiscal courts quarterly.
And Debbie, you may not have the answer for this. I don't know, but when did that take place with the difference between the larger counties and the smaller counties? And do you know the impetus behind?
You know, I'm wanting to say 2002, but I'm not sure on that. I can get that answer for you.
Okay. Well, I know there has been some questions amongst the committee of why the difference in the tiering of the two different groups and what brought that along. So if you could find any background on that.
I'll have that to you today.
Thank you. Other questions from committee members? Anybody online that has a question?
I guess maybe a quick one, Mr.
Central Wheeler, go ahead.
Ms. Donnelly, are you all, I guess, for clerks in your situation, are you all, requesting any change in that per se? Or I guess, is there ideas that you have on that to maybe fix some of the difficulties?
Well, actually, it works well for us.
Okay.
Used to, we were paid weekly before this went into effect. And now we're paid every 2 weeks. And so it was an adjustment to that, but now we're used to it. And we in our county, all employees receive their checks through direct deposit.
So y'all are generally satisfied with the mechanism then?
Yes, sir.
All right, thank you.
You're quite welcome.
And Central Wheeler, I don't think we were trying to address the issue from a standpoint of any change. Wanted everybody to be understanding of how the different funds flow for different types of offices, because I think that will affect anything that we may do with regard to other excess or with regard to permanent storage fees or anything like that, because you'll have to treat each group differently because of the way the statute's currently written. And just wanted everybody to have an understanding of how that process worked. Any other questions for Ms. Donnelly?
Can I say something that you brought up, the document storage fee?
Go ahead.
Whether you're a large county or small county, that money needs to stay with the clerks, because no clerk can purchase what we need to maintain the real estate side of the office, and especially in this e-recording, because there's some counties that are having to start from scratch with new hardware, new software, personnel to get their documents online. So we all need that money. And if that could stay with us to the end of our term, and there again, I'm talking about elected term, because that money needs to build up, because it's hard to, as you all know, things are expensive. So we need that money in order to be able to take care of our offices, to be able to put that out there for you legislators, our general public. So if you can leave that document storage fee with us for the end of our term, then we could take care of our office in a sense.
Seeing no other questions for Ms. Donnelly. Ms. Donnelly, thank you for your presentation.
You're quite welcome.
Move on to our final folks on the agenda. Mr. Barry Tumler, I hope I'm saying that correct, with Kentucky Land Title. This is going to kind of take us back a little bit to our first meeting of the task force, where we had our land title attorneys and business groups here. And I think the specific goal of the presentation from Mr. Tumler is to kind of show us everything that would be needed to be indexed in our clerk's files to be able to do a full-blown title opinion, and how those years and everything would work with the way the court's set up as well. So if you would go forward introduce yourself for the record, and then move forward with your presentation.
Thank you very much, Mr. Chairman. My name is Barry Timler. I am here representing the Kentucky Land Title Association today. I've been involved in the title insurance industry for over 35 years here in Kentucky. Started up in northern Kentucky where I have been raised and still live, up in Kenton County and Campbell County, Boone County, searching titles back in the 1980s. So I've been involved in just about every facet of this business that there is. I currently work for a national title insurance company and work with real estate attorneys throughout the state of Kentucky and title agents throughout the state of Kentucky every day in order to facilitate real estate closings and to ensure good title to real estate on an everyday basis. So I have a good idea of how the system works, and what my intention is here today is, as the chairman mentioned, is to just give you a kind of a brief outline of the process that we go through on an everyday basis in order to search the title records and ultimately ensure or certify good title to property that individuals are buying, either in their individual name or commercial property incorporated names. In many cases, these real estate closings represent the largest investment that an individual will make in their life if they're buying their home. And the primary purpose, the primary goal of the title agent or the title attorney that is closing the transaction and insuring that property is to make certain that when that buyer leaves that closing table, that they have good title to the property that they have invested in. That they have good title, meaning essentially that no one else, no other individual, no other company, no other corporate entity in the world has a claim or an interest in that property that they've spent their money on, they've purchased. A lot of different ways that you can obtain an interest in a piece of property other than by way of a deed, where you're buying a piece of property, you receive a deed, you obtain title to that piece of property. So you own the property pursuant to that deed. But there are many other ways that a company or an individual can obtain or have an interest in property that you may not know of. And the only way to discover that is by way of a title search in order to make certain that there aren't any title defects in that. Just a few examples just to give you an idea of what I'm referring to as far as the many different ways. If you own a piece of property and you are sued by a credit card company, and they obtain a judgment because you did not pay your credit card off properly, and you're in default on that credit card. They obtain a judgment against you. They convert that judgment into a judgment lien, and that judgment lien is filed with the land records in the county clerk's office. That judgment lien attaches to every piece of real estate that you own, meaning that that judgment creditor needs to be paid and satisfied as far as the underlying judgment before, in order to wipe out that judgment creditor's interest in the property. All right. If you own a piece of property back in the chain of title, so I'll talk a little bit more about that later, and not great detail, but if you own a piece of property back in the chain of title and you sell it to someone, you execute a deed in order to convey that piece of property to the buyer, the grantee in that deed. If that deed is in some way defective because it's not properly executed, it's not properly acknowledged by a notary public, the legal description is perhaps wrong to the point where they can't specifically identify the piece of property. That's a void. It's not a void deed, but it's not an effective deed, so it doesn't effectively convey title to property. The individual who owned that property in the past and signed that deed as a grantor still owns that property. If that deed is defective, it doesn't effectively convey that property. So you have a break in the chain of title, meaning that that individual who owned the property way back in the day, who received money in order to consideration to sell the property, to convey it, they still own title to that property. They have an interest in that piece of property. So these are all different things that when you do a title search, the title attorney, the title agent is making certain that no one else has an interest in your property. And everything starts with being able to access the records at the county clerk's office in order to search all the documents. I think I've handed out a list. Hopefully you received a handout as far as that's concerned, but in order to properly search real estate back and establish a chain of title and make certain that there is no other company, nobody else that has a claim to your property or interest in your property, you have to be able to search the indexes or the indices in the county clerk's office in order to establish that chain of title. And then you also have to be able to review and all these different documents that I mentioned here, from deeds, mortgages, power of attorneys, easements, land contracts, wills, all of those documents need to be examined and reviewed in order to make certain that they were properly executed, acknowledged, recorded, and to make a decision as to whether or not those particular documents affect the chain of title or affect the good title to that property. If you take a look at that list of documents, if you take a look at the first 11 there, where you talk about deeds, mortgages, UCC fixture filings, et cetera, as you go down to number 11, all of those documents are used to establish title and establish the chain of title, all right? So each one of those have to be properly examined in order to determine the content and to make certain that they were properly executed, as I mentioned. You also have to take a look at documents such as easements to know if they affect your property. There may be an easement that was filed back 30, 40, 50 years ago that gives access to your adjoining property owner, to your neighbor, to come across your property in order to get to the public road, the public highway. And that might be that adjoining property owner's only form of access. Without doing a title search and reviewing that easement, you don't know that that individual, your next door neighbor, actually has an interest in your property, an interest by way of an easement that allows that person to gain access and go right across your property for the purpose of access. Leases, if your property had been the subject of a leasehold agreement sometime in the past, it might be a mineral rights lease, something of that nature. You need to take a look at that leasehold agreement, examine it, see if it's still an effective lease. It might be for a term of 5 years, it might be a term of 50 years, but you need to take a look at it and see if it still affects title to your property. So those first 11 documents essentially are what you're looking at there. And those documents, we would need to research back at times 60 to 70 years. So we would need access, if it's online access, we would need access to be able to review those documents back probably, like as I mentioned, 60, 70 years. All those items under number 12 are different types of liens or encumbrances against the property. And with those documents, and I mentioned that a little bit earlier, if you don't pay your taxes, the federal government's going to file a tax lien, a federal tax lien against you, and that tax lien affects every piece of property you own, all right, in the county. Same way with judgment liens, state tax liens, homeowners association liens. These are all types of liens or encumbrances that are filed, and they will attach to your property and affect the good title to the property. So all of those liens, though, they come with statute of limitations. They're only effective for a limited period of time. So in the case of all the different liens, there are shorter periods of time that we would need to review those documents. Typically 15 to 20 years would be probably the maximum. For instance, judgment liens are good for 15 years. Once a judgment lien is filed or recorded, that judgment lien is good for 15 years. All right. After that, it no longer affects or attaches to property. State and federal tax liens are 10 years. So only back 10 years in order to review those documents. Homeowners association liens are 5 years. Child support liens, that's a kind of gray area, but probably 20 years is effective. So those we being title searchers would not need to be able to review those back 60, 70 years. We wouldn't have to do that. They would only have to go back probably, like I said, 15, 20 years for the whole bunch would be fine. So that's essentially, what we do as far as the title industry and able to ensure good title. You have to have access to the records, to the search records. Back in March of 2020, when the pandemic hit, there were a few clerk's offices that had to close for one reason or another, and that that put us out of business, number one, but it also stalled the idea of being able to buy and sell property, because you can't buy and sell property typically in today's world without knowing that you're going to get good title to your property. If you are a residential home buyer, typically you're going to be mortgaging that property. When you go to the lender in order to negotiate your mortgage loan, that lender is going to contact initially a title agent or a real estate attorney and ask for a title search to be done, and ask for some type of a title policy or title certification to guarantee them or ensure them that when they enter into the mortgage agreement with their mortgagor, with the buyer of this property, that mortgage is going to give them first and best interest in the property. So they have to make certain that the individual who owns the property, the current owner, currently owns the property and can convey good title to the property. Much less the buyer, who needs to make certain that they're not spending their money on a piece of property that they don't own outright. So it all, as I mentioned earlier, it all starts with having access to the county clerk's offices. Online records were a godsend during the pandemic, when a lot of the offices around the county clerk's offices were closing, either temporarily or on a limited basis. Those county clerks that do have online records were an absolute godsend for our business, and it enabled us to continue to facilitate closings, real estate closings here in the state of Kentucky. Also, on the back end, it's very important as far as the electronic recording, because it's important in order to get a deed or a mortgage or any other real estate document has no effect unless it's recorded. It needs to be recorded, and it has to be recorded in a timely manner. In order to efficiently and timely record documents, the electronic recording is what needs to be done and is the most efficient way to do things. So I'm not sure if I covered everything that you wanted me to talk about, but I'd be more than happy to answer any questions that you might have.
Mr. Timler, real quick question from me, and it's just a kind of a technical. You had mentioned on the things under category 12 there
Yes.
that had statutes of limitations.
Yes.
As far as the other ones that you didn't go over, as far as recoupment
Okay.
and unemployment liens, what's the statute on them?
Yeah, that's a kind of a gray area, but probably 20 years would be sufficient.
Liz Pendens,
Yeah, Liz Pendon's 15 years,
bail bonds,
5 years,
and civil penalty liens.
10 years.
And then the only one, and I'm just thinking from practical use of it, on the top 11, UCC fixture filings would be less than 30 to 60 years. They have a
Yes,
statute
yes.
on too. What's
Those
the
are
statute on them?
It's actually 5 years unless it's associated with a mortgage of a record. So 5 to 10 years would be sufficient with UCC fixture filings.
Okay. Other questions from members of the committee? Senator
Yes, sir.
Howell?
Mr. Timler, thank you for going into that in great detail. I think it's important for everyone to hear all that's involved in that. I especially think it's important for lenders to hear about all the great services that real estate attorneys do for them when it comes time to write their checks on it. So, for the benefit of going through a lot of this stuff as an insurer of a lot of these issues, talk a little bit, if you will, about the validity of the online searches being as good as doing a live search in the clerk's office as far as availability of records, the indexing, and this sort of thing. I'm going to have two questions, and the crux of it is the gap between the unknown and the unusual of going online versus in.
Okay, we give as much credence, our title searchers give as much credence to the online records as they do the physical records within the county clerk's office. All right, so now are you referring, Senator Howell, to a gap as far as the recording or the indexing of those documents that might be online?
No, sir, that would be no different.
Okay, all right.
I'm just talking about there's some of us are more farther along on this process than others, and certain areas have some concerns about if the index that is online is as good as what we have in the books.
With the rare exception of certain county clerks that that have issues, I would say that the online records are just as good as the physical records.
And kind of the same type.
As far as we're concerned, as far as our standpoint, our We give it, like I said, as much credence to the online records as we do.
And same question for not having to actually deliver an original document to the clerk's office in order to be able to record it and enter it into the records. Through the process of online filing, it has the same validity and effect as if we hand delivered it or mailed it to the clerk's
Yes, it
office.
does. Yes, absolutely. Yes.
In fact, in a lot of these, it's going to make the real time and eliminate a lot of the gaps in the recordings to actually make this process a little more reliable from a timeliness standpoint. Is that not the case?
That's an excellent point. Yes, absolutely.
Thank you.
Yes.
Senator Howell, just want to clarify that we express our appreciation very often through those steep fees that you all charge as real estate attorneys.
Glad to be appreciated.
Senator Wheeler, you had a question?
Thank you, Mr. Chairman. On some of the items you mentioned, I think that the chairman talked about, now some of those items like a judgment lien, they can actually be renewed for longer periods, can they not?
Judgment lien, no, you cannot. It's 15 years.
15 years?
Yes.
Okay. I thought there was a process that you could get that. All right, fair enough. Thanks.
UCC fixture filing can be renewed. Federal liens can be renewed. They have within 10 years to do that, but not regular judgment liens.
Other questions from members of the committee? Representative Bridges.
Just got one quick question. You said you'd recommend up to 20 years on some of these searches going back. On the title insurance, you do the work, but you use outsource for insurance. Is that correct?
Well, I actually work for a title insurance company. We're the underwriter. Okay. And in Kentucky, we have various title insurance agents who write the title insurance policies on behalf of our company.
Okay.
All right. They do the work. The title attorneys, the title agents do the work. They do the searches. They clear title.
I understand that.
Yeah.
I'm a real estate broker. So
Okay.
I'm just to get to the point of my question, and what pricked my mind was, do we need a statute that limits that to 20 years? Because you're saying 20 years. What if we put these criteria in order and regulations or whatever, we're going to go back 20 years or 30 years or whatever, the records we keep, and then another title company in Eastern Kentucky or one in Western Kentucky goes in and they're using these guidelines, and then their companies won't insure, won't cover this in their insurance policy. So I'm just wondering, do we need a guidelines to go by so that we can that's your recommendation, but some insurance companies will not not insure for your recommendation.
That's a great point. Let me address that if I could, because I meant to talk about that and I did not. In Kentucky, we do not have what other states call a marketable title act. In Ohio, for instance, they have a marketable title act that says that if you research property back 40 years, I'm not sure about that, research property back 40 years, anything prior to that cannot affect the good title to your property. All right, we do not have that in Kentucky. In Kentucky, by custom and by industry practice, we have established time periods of 30 years for residential property to take the property back 30 years, and for commercial property back 60 years. So that's where the 60 years comes from as far as being able to examine deeds, mortgages, easements, et cetera, back 60 years, okay? And as far as the title insurance underwriters who insure these, they're in step with that. All of the title, we go pretty much by what the customer practice is in the state. But nationally, I can tell you that those are pretty much the standards nationally too in other states. 30 years for residential searches and 60 years for a commercial piece of property.
Well, I appreciate your testimony. Thank you, Mr. Chair.
And I think Representative Bridges, if there was any clarity probably needed on some of that, when you look at the things under number 12 there, most of those have statutes of limitations specifically set in statute. The ones that he mentioned is the 20 years, the unemployment liens, the child support liens. They're probably just not as clear to have a clear statute of limitations like the other ones in that category.
Correct.
Is why you're saying 20 years.
Yes.
The 30 and 60 is what I've always heard of as an industry standard. And just to further that question a little bit, I would think some of that interplays with the adverse possession law. Would that be correct? Because if you've had title to a property for a certain amount of time, and you thought it was a clear title, that would play into that role, correct?
That is correct. The time is 15 years. If you own property outright and adversely possess it for 15 years, you can be declared as the owner of that property.
Any other questions from members of the committee in the room or virtually online participating? Seeing none, appreciate your testimony, Mr. Timler.
Thank you very much.
I will just ask, I know we have some representatives of the Clerks Association in the room, if they had any comments with regard to any of the things that we had today, briefly, as I think this will be kind of our last meeting that's going to be focused on property records, and we will be moving into automobile, title, and vehicle issues next meeting, probably with some cleanup at the last meeting in November with regard to both sides. But don't feel pressured, but if you had anything you wanted to add real quick, I wanted to give you that opportunity.
Representative Meredith.
Yes, Debbie.
This is Debbie. The KRSs that you need over the 70,000 is KRS 64.345. That started in January 1st, 1994, and was amended July the 15th, 2002, and that KRS is 64.350.
Thank you, Debbie.
You're quite welcome.
Thank you for inviting us up. I'm Tabitha Clemens, the Grant County Clerk, and Jason Denny, Anderson County Clerk's here as well. We just wanted to take a moment, since Debbie explains the 75-25 over 70 counties, just to reiterate about non-fee pooling counties. So they're the counties that do not send their monthly money over to the fiscal court. They keep that money for the year, but then do turn that over by March 15th every year, all of the excess fees, and essentially start every January, because you cannot commingle the accounts from year to year. Every January starts at zero. So while this 75-25 counties are keeping those fees for the 4-year term, the smaller counties that are not fee pooling or fee pooling counties as well are starting every year with zero in the bank. So just wanted to clarify that to make sure that all the committee members understand that.
Senator Mills.
Thank you, Mr. Chairman. Just a question of clarity on that. So some county judges float clerks loans and money to do that, or is that just an understanding between county to county? Would it be clear if they had the ability to do that, or were encouraged to do that, or what's your opinion on that? And what do they do in your counties?
So in Grant County, we start every year with zero. I'm a non-fee pooling county, so the only things that I pay to the fiscal court on a monthly basis are the ad valorem taxes, delinquent taxes, and deed transfer tax that we collect. Then yearly, I give them all excess fees. Every January, I start with zero. I have a good working relationship with our fiscal court and Judge Executive Dills, to where, like this year, the way that the calendar fell, I had 2 days to make enough revenue to make payroll. So if need be, if I didn't, my fear was something more would happen with COVID and we wouldn't be able to open, or we wouldn't have the amount of work that we need to start the year off. And we have a good relationship that if I needed a few more days to get that check to them to make payroll, that we could do that. I pass my payroll through the fiscal court that goes to a financial accounting agency to handle our direct deposit and things. So they could help me if I needed it. I've never had to do that. And I'm in my second term, never had to do it, but always have that relationship that if I need to, I could. The small counties that are under the 20,000, right? Under 20,000 mark, they do get a payment from the state. It's out of the third dollar collection of the state fee for motor vehicles. the registration fee. They don't get that payment though until sometimes mid to late February. So while they're getting some help and they need that help, not questioning that at all. The timing of the help is difficult. They're not seeing that money float back into their coffers to be able to pay their employees and that sort of thing. So I didn't recognize this until we started some of these discussions. I had some of those small counties reach out in regards to some questions from a survey that we sent out. And some of them have had times that they couldn't pay their employees because their fiscal courts couldn't help them.
I've heard they took a personal loan out
Correct.
to pay their payroll. Yeah.
That is correct, Senator Mills. Yes, that's exactly what they've explained to me. They had to take out a personal loan or write a personal check in order to make it work so that their employees could be paid. That's right.
I run under pretty much the same rules as Tabitha does. Early on in the year, my fiscal court I go about a month before I reimburse them for the payroll they've made once we have the money, and they're fine with that. I was on our fiscal court before as a magistrate, so I understand those restraints, and worked with the clerk then. So been in the clerk for 14 years now, and we've still got that relationship that I educate my fiscal court. They understand what our problems are, our issues are, and they're more than willing to help out and work with that. So,
Any other questions or comments from members of the committee? Seeing none, I think we have everything covered. Do I have a motion to adjourn? Second. All in favor? Meeting is adjourned.